Hello and good day everyone. My name is Jajin Harith and my team and I will be discussing to what extent utility innovations provide important and distinct legal protection in Malaysia. I will start off with introduction, continue with pattern, then introducing utility innovation, similarities and differences, the importance, and we will end with a conclusion. So, what is a patent? Patent is concerned with the protection of inventions which are new, involve an inventive step, and are industrially applicable. A patent is granted by the government of a limited monopoly to an inventor for his new invention. In return, the inventor is required to publicly disclose his invention so as to add to the pool of existing knowledge in a particular field of industry. This public disclosure would benefit society in that those who are skilled in the particular field of industry can deliberate on the invention and make further innovations or improvement to existing technologies. In Malaysia, as patents are governed by the Patents Act 1983 and Patents Regulation 1986, in order for a patent to be protected in Malaysia, an applicant must file a patent or a utility innovation with the Intellectual Property Corporation of Malaysia, which will assess whether the patent meets the requirements of Patents Act 1983. The term of protection for a patent is 20 years from the date of filing of a patent application. Malaysian patent law is governed by the Patents Act 1983, which, inter alia, provides for an administrative structure for the proper administration of the Act and spells out the procedural and substantive aspects for the grant of a patent. In the nature of the exclusive right of a patent owner, the circumstances in which the exclusive rights is infringed, the limitations and exceptions to the exclusive right and the commercial exploitation of a patent. Pursuant to Section 87 of the Act, the Patents Regulation 1986 were made for the purpose of carrying into effect the provisions of the Act. The main thrust for enacting the Patents Act 1983 was to stimulate inventive activities in this country, and in this regard, statistics have shown that the number of patents granted to local applicants has on the average steadily increased over the years.
Hi, my name is Jackson Tan Jie, and I'm going to discuss on utility innovations. For a patent to be protected, the patent application is required to satisfy the demands of the Patents Act 1983. The requirements relating to patentability criteria are exacting, and the procedural steps that have to be complied with are detailed and time-consuming. Thus, there exists another type of intellectual property that's very similar to patent. It is an exclusive rights conferred to an innovator that manages to come up with an incremental improvement to an existing product or process. Utility innovations are inventions that is worthy of protection because they are commercially viable inventions. The scope of protection is narrower and the initial duration of protection is shorter. However, the requirements to obtain a certificate of utility innovation are less stringent than patent. It is also known as utility model, minor patent, petty patent, and innovation patent in some other countries such as Australia. The Malaysia Patents Act 1983 provides protection to utility innovations through the utility model system. The system operates by way of registration and the creation of a register for certificate for utility innovations spelled out in Section 32 as modified in the second schedule to the Act. This form of protection requires the satisfaction of a lower level of patentability criteria. Section 17 of the Act defines a utility innovation as any innovation which creates a new product or process or any new improvement of a known product or process which is capable of industrial application and includes an invention. The protection of utility innovations is dealt with in Part 4A of the Act, that is Sections 17 and 17A. read together with the second schedule to the Act. The provisions of the Act apply to utility innovations in the same way as they apply to invention, except on specified provisions which are expressly excluded and subject to modification in the second schedule to the Act with regard to utility innovations. The provisions which are expressly excluded are spelled out in Section 17A2 as follows. Number 1, Section 11, which spells out the patentability requirement for an invention, namely new, involves an inventive step and is industrially applicable. Section 15, which explains the concept of inventive step. Section 26 on utility of invention, which requires an application to relate to one invention only or to a group of inventions so linked as to form a single general inventions concept. And Part X on compulsory licenses. Section 89 on the repeal of previous acts and saving provisions. Section 90 on transitional arrangement. The exclusion of Part X also means that utility innovations are not subject to compulsory license provisions. An application for a certificate for utility innovations should also only contain one. An application for a certificate for utility innovations should also only contain one claim pursuant to the modification made to Section 28, Subsection 1D. Thank you.
Hi, my name is Chan Xuan Yao and I'll be talking about the similarities and differences between utility innovation and patent. Utility innovation is very similar to patent. However, there are several differences between a patent and a utility innovation. A patent is an exclusive right granted for an invention, which is a product or a process that provides a new way of doing something or offers a technical solution to a problem. A patent provides protection for a period of 20 years from the date of filing. On the other hand, in Malaysia, utility innovation differs from patent in the sense that the scope of protection is narrower and the initial duration of protection is shorter. Moreover, a utility innovation is an exclusive right granted for minor invention. The requirements for acquiring a utility model are less strict than for patent. Utility innovations are protected for an initial period of 10 years, which may be extended for another 2 5-year terms, providing a total protection of 20 years. However, Section 35, Subsection 3 of the Patents Act 1983 requires that an application for extension must be accompanied by an affidavit from the utility innovation's owner, certifying that the utility innovation is in commercial or industrial use in Malaysia. On top of that, as mentioned before, the requirements to obtain a certificate of utility innovation are less strict than the requirements needed for patent as a result of exclusions of Section 11 and 15. Therefore, utility innovations in Malaysia need only to be new and industrial applicable, and there is no requirement for an inventive step, unlike the situation of patent protection. The first requirement for utility innovation is novelty. It means that the invention must be new and not used or disclosed before anywhere in the world. The second requirement, industrially applicable, means that the invention can be made or used in the relevant industry. Furthermore, an owner of utility innovation similar to patent will have the exclusive rights to exploit the covered subject matter, chiefly to make, import, offer for sale, sell, or use the registered innovation. Furthermore, the owner also has the rights to assign the utility innovation and to conclude license contracts with any other party. This shows that there are several differences between a patent and a utility innovation. However, it is evident that there are also some similarities in terms of exclusive rights.
Hello, my name is Nabil and I would be discussing how far utility innovations provide protection in Malaysia and why protection provided by utility innovations are important. As mentioned earlier, utility innovations in Malaysia is governed by the Patents Act, specifically Section 17A, read together with the modifications regarding utility innovations in the second schedule. They highlight that other than the modification and exclusions highlighted in the section, All other provisions of the Patent Act applies to utility innovations the same manner. This is to mean that the filing procedure and rights and enforcement would be the same as a patent. When examining the exclusions highlighted in section 17A subsection 2, it is clear that the exclusions of section 11 and 15 mean that the utility innovations do not require an inventive step. Rather, an incremental innovation can be argued to be plausible to be protected under utility innovations. This illustrates that the Malaysian law on utility innovations is broader or some would call weaker than, let's say, Indonesia, where inventive step is required for their petty patent. In addition, other than the compulsory license in Part 10, utility innovations are also excluded from Section 26 with regards to unity of invention. This illustrates how utility innovations are allowed to only have one application per claim. Arguably not significant, may narrow the scope of protection of the utility innovations. In regards to the modifications of the second schedule, it is important to note that when satisfying the novelty element, Section 14 subsection 1 makes it clear that prior art includes that in Malaysia only. This domestic novelty best illustrates the wide protection the utility laws in Malaysia provides. This is seen further in Section 35 subsection 3, which requires the extension of application requiring an affidavit from the owner of the commercial or industrial use in Malaysia, again showing us that the Malaysian law on utility innovations considers domestic novelty. Finally, although it is clear that generally the utility innovation laws in Malaysia seem wide, actions taken against infringement must be taken within 2 years as compared to the 5 years that one has against infringement of a patent. So why is utility innovations important in Malaysia? As mentioned earlier, the simplicity of the process of application of utility innovations compared to that of a patent makes the process faster, cheaper and easier. It is important to note that the lower application costs and maintenance costs are fundamental reasons why utility innovations are important in Malaysia. This is because managing innovation better than its competitors is one of the main objectives that businesses have to have, and it is necessary to survive and thrive in today's economy. This second-tier patent regime is viewed as an ideal solution as it is a system geared towards the needs of small and middle-sized entrepreneurs, specifically in terms of costs. These small middle-sized entrepreneurs involve sole traders and partnerships, often innovating in short life cycle technologies or amongst their own community. And it is not surprising that the data collection from 1989 to 2003, the most amount of utility innovations in Malaysia, with 24.9%, was for human necessities, which included agriculture, footwear and jewelry. Furthermore, it is important to note that in Malaysia from 1999 to 2003, companies filed 34.2% of the total number of utility innovations, whereas individuals amounted to 65.8% of the total number of utility innovations. This trend is further seen by the statistics from WIPO, which highlight that from 2009 to 2016, the number of residential utility innovation applicants have increased, and whereas the number of non-residential applicants have fallen. These statistics further illustrate the importance of utility innovations in Malaysia, as it is often utilized by small businesses and greatly by individuals to protect their minor inventions and encourage small-scale innovation. In addition to these and other practical benefits such as the government revenues from applications and maintenance fees, there are other macroeconomic reasons of importance for providing utility innovations. This is because the pressure to innovate encourages economic growth, and governments use utility innovations and patents to facilitate the catching up of the economy. This is best illustrated by observing China's management of utility innovations, where out of all the IP rights granted, 2/3 of the rights were for utility innovations. And China took a policy decision to transition from imitation to innovation by strengthening their patent regimes. This is one of the clear examples of how patent and utility patents can be used to encourage innovation and manipulate economic growth. Looking back again at Malaysia, here it is important to note that the TRIPS agreement that the Malaysia is signatory to does not specify provisions relating to utility innovations, leaving the state to decide how to regulate it. This also explains the differences between developed countries having stronger patent or utility regimes and developing countries having weaker regimes. Having said that, scholars have warned that developing countries do not need patents but need utility innovations, and that developing countries should not make the rights relating to utility innovations or inventions strong until the economies have advanced. Weaker regimes such as the one in Malaysia allow space for imitation, which is essential in learning to innovate, and technological learning, which leads to incremental developments, do ultimately lead to higher levels of innovation. Finally, other than the commercial importance and strategic economic growth, the importance of utility innovations is clear when one observes that the inability of the patent law to extend their legal rights to inventions of lower threshold and the limitation this places on encouraging innovative activity leaves any discovery, innovation or invention that falls short of the bars of an inventive step or novelty being unprotected. Utility innovations fills this lacuna in the law by providing a distinct, important and legal rights to protect innovations faster, cheaper and simpler than a patent.
Hello, I'm Stephanie Jambi and I will now move on to explore the unique protection conferred to utility innovations in Malaysia in comparison to other jurisdictions. Firstly, we will consider the prerequisite of substantive examination that is required before a certificate for utility innovation can be issued. Malaysia differs from other jurisdictions such as Taiwan province in China, which hold no such requirement. This peculiar position can be justified by the fact that Malaysia offers a longer duration of protection, that is 10 years as per section 35, and is open for extension of 2 terms each amounting to 5 years. This can be said to operate as an incentive for small and medium-sized enterprises to apply for utility innovation, seeing as the same rights granted to patents are also provided. Now, as it stands, Malaysia comes in second as one of the main users of the utility innovation system, accounting for 38.9%. China is the first, accounting for 47.3%. And despite a lower duration of protection, that is 10 years, and this is expected seeing as China does not subscribe to the more thorough examinations and requirements as Malaysia. For there is no test for novelty or a grant for there is no test for novelty before a grant for utility innovation is issued. Moving on, we will now examine the flexible nature of patent law in Malaysia. As mentioned earlier by my colleague, an application for utility innovation can be converted into an application for a patent and vice versa as per section 17B. This offers applicants the option to switch the application if they fail to meet the prerequisite requirements. This position is similar to Germany, where it's not uncommon for investors to file patents and utility models simultaneously. However, both jurisdictions maintain that only one grant can be issued and if it concerns the same subject matter. Finally, we will briefly look at the United States of America and its position towards minor inventions and how this differs from Malaysia. The United States of America do not have a utility model. Minor inventions are subjected to the patent system. There are many justifications as to why they don't subscribe to a utility model, namely, most innovations and inventions emanate from large transnational corporations rather than small, medium-sized enterprises. Thus, stimulating competition within a domestic market is not really a priority, seeing as America is the leading intellectual property producer. Now, in summary, protection conferred to utility innovations in Malaysia is not so distinct when compared to other jurisdictions. Yes, there are minor differences, but these differences can be attributed to procedural requirements rather than substantive requirements. Thank you.
To conclude, utility innovation clearly provide for a distinct and important legal protection in Malaysia. Albeit the fact that it is fairly similar to patent, the key differences must be highlighted. Protection for utility innovations are crucially as important as they are commercially viable inventions and are the result of creative thinking, innovative activities, as well as the expenditure of time and money. That is all from us today. Thank you and have a good day.